Hello, everybody. My name is David Kelly, and I'm the Executive Director here at the British Chamber of Commerce in Singapore. And a very warm welcome to today's webinar, which is a BritCham Presents session, where our guest speakers today will share updates on Brexit and where we are today. I'd like to thank our event partners for today's session, HFW, for joining us and for sharing their insights on Brexit. It has been 5 years since the UK voted to leave the European Union, and the challenges of decoupling from the trading bloc have been exacerbated by the additional hurdle of a global pandemic that we're all still in the midst of at the moment as well. Today, Anthony Woolich, partner at HFW, and Nicola Gare, global disputes professional and support lawyer from HFW, will cover the UK's trading relationships, commercial impact to date, effects under English law, commercial contracts, disputes, data protection, competition policy, customs and sanctions. So a really, really great session ahead of us. This is another interactive event. So if you'd like to ask a question to our speakers today, please post your questions to the dedicated Q&A box on your Zoom toolbar. And I'm sure we will be able to try and answer those throughout the session. The session is also being recorded and will be available on our on-demand section of our website and through our social channels too. So if there is anything in today's session that you'd like to revisit, you will be able to, and we'll make sure that you get a copy of that too. So with that, I'd like to hand over to Anthony and to Nicola to kick off the session. A very, very warm welcome to you both. It's great to have you with us and really looking forward to this session. Anthony, over to you.
David, thank you very much for that kind introduction. So I'm going to start today with the initial topics which David mentioned, and then I'll hand over to Nicola, who's going to handle disputes, and then she'll hand back to me, and I'll finish off with the latter topics which David mentioned. So starting then with the UK's trading relationships, and I should also say that we will leave questions at the end, time at the end for Q&A, and indeed we've already received a couple of questions from members of the audience which we'll pick up as we go through. So on the UK's trading relationships, the UK-Singapore Free Trade Agreement entered into force on the 11th of February of this year. It's the first free trade agreement that the UK has entered into with an ASEAN nation and is estimated to cover over £17 billion of bilateral trade. The UK-Singapore Free Trade Agreement seeks to reduce frictions and facilitate ease of access and movement of goods and services between the two nations. The agreement seeks to maintain continuity with the EU-Singapore Free Trade Agreement, with UK and Singaporean businesses receiving the same benefits as those under the EU-Singapore Agreement. These include tariff elimination for goods, increased access to government procurement markets, as well as the reduction of non-tariff barriers. The UK-Singapore Free Trade Agreement eliminates 84% of tariff lines for all Singaporean products entering the UK. By 21st of November 2024, tariffs on virtually all remaining products will be eliminated. This matches the timeframes for tariff removal in the EU-Singapore Free Trade Agreement. Import tariffs have been removed from all goods entering Singapore from the UK. The imbalance here is due to Singapore's already highly open trading regime. Singapore operates only 6 tariff lines on stout and porter, beer and ale, and medicated and non-medicated Samsu, which have been eliminated under the terms of the UK-Singapore Free Trade Agreement. Singapore operates a system of eliminating all tariff lines for imports from free trading agreement partners. The agreement includes provisions on rules of origin, preferential tariffs and quotas. It also contains commitments in areas such as intellectual property, geographical indications, and government procurement. The UK-Singapore Free Trade Agreement, incorporating the terms of the EU-Singapore Free Trade Agreement, focuses on eliminating and reducing non-tariff barriers in 4 major sectors. Non-tariff barriers are to be eliminated for electronics, motor vehicles and vehicle parts, pharmaceutical products, and medical devices. Non-tariff barriers are to be reduced with regards to trade and investment in renewable energy generation. Each of these sectors is explicitly explicitly referenced within the agreement. The agreement sets out a number of actions that both nations must engage with regarding non-tariff barriers. The UK and Singapore confirmed that they will base their standards and technical regulations on relevant international standards, eliminate burdensome conformity assessments, and enhance cooperation to foster the development within these sectors. Measures referenced directly in the agreements include coordinating regulatory standards, removing the requirement for conformity assessment procedures where the imported product has been declared to comply with the applicable technical regulations on safety in the exporting country, and a commitment not to unduly delay the placing of a new product on the market on the grounds that it has not yet been regulated. Concerning renewable energy, the agreement sets out that both nations will foster regulatory convergence and refrain from imposing onerous compliance measures. The agreement references a need for both nations to promote and develop renewable energy in line with global efforts to reduce greenhouse emissions. The UK-Singapore Free Trade Agreement incorporates the terms of the EU-Singapore Free Trade Agreement by directly referencing the content of the EU-Singapore Agreement. However, there have been some revisions. Origin quotas have been retained but resized to reflect the size of the UK market. EU free trade agreements contain geographical indications which outline a system of protecting the names of products that originate from specific regions in the community and have reputations linked to those regions. The UK-Singapore Free Trade Agreement has removed all references to these, with the exception of those relating to Irish whiskey and Irish cream, which originate in Northern Ireland or the Republic of Ireland. Concerning sector-specific commitments, the number of permitted customer service locations for UK retail banks operating in Singapore is increased from 25 to 35. The UK-Singapore Free Trade Agreement provides liberal and flexible rules of origin for UK and Singaporean key products entering one another's markets. Goods qualify as originating in either the UK or Singapore, where they are processed in the respective nations, affording greater ease of access for goods. The UK-Singapore Free Trade Agreement does not replicate the investment protection measures within the EU-Singapore Free Trade Agreement. The UK and Singapore are proceeding with further negotiations to secure an investment protection agreement to replace the current agreement that exists between the EU and Singapore. Negotiations are ongoing with regards to a digital economy agreement between Singapore and the UK. This agreement will strengthen cybersecurity and digital trading protection measures between the two countries, enhancing security and service provider coordination within the digital economic sphere. The UK is proceeding with a programme of negotiations to replace existing free trade agreements that the EU has entered into with a number of nations. Replacement agreements at large follow a similar structure to equivalent EU free trade agreements. They commonly incorporate many of the terms found within the EU free trade agreements through direct reference to the text of the EU free trade agreement. Replacement agreements will diverge from the EU free trade agreements by removing explicit terms that apply to the EU. This will include the resizing of quotas to reflect the nature of the UK goods market and the removal of geographical indications that the EU imposes on goods from specified regions within the Union. Some replacement agreements, however, have incorporated more substantive changes to the terms of EU trade agreements. The UK-Switzerland Free Trade Agreement entered into force on 1st of January of this year. While this agreement sought to replicate the effects of several EU-Switzerland agreements, the UK-Switzerland Agreement revised rules of origin, mutual recognition, imposed further tariffs on certain agricultural goods, and revised the customs procedures between the two nations. The UK-Switzerland Free Trade Agreement included an article that explicitly provides that the two nations will undertake discussions to replace and further develop the trade agreement that currently exists between them. The UK has already secured over 30 replacement agreements with trading partners around the world. These include replacement agreements with Canada, Vietnam, and Israel. Ongoing negotiations are taking place to secure replacement agreements with Algeria, Bosnia and Herzegovina, and Montenegro. Continuity of trade relations, tariffs and quotas are ensured through these replacement agreements. Businesses benefit through the certainty afforded by these agreements, as there has not been a substantive revision to the terms of bilateral trade following the UK's departure from the EU. The UK is engaging in substantive negotiations to secure new trade agreements with the USA, India, and the Gulf Cooperation Council, the Middle Eastern Regional Political and Economic Union of Bahrain, Kuwait, Oman, Qatar, Saudi Arabia, and the UAE. These agreements would not replicate the existing provisions of EU free trade agreements, but rather afford new and more comprehensive revised trading relations. There is a clear demarcation between older and more recent FTAs globally. Increasingly, free trade agreements are becoming more detailed and comprehensive, naming key goods and services within their scope. It's expected that future comprehensive free trade agreements will address detailed points relating to the movement of goods and the provisions of services, as well as addressing such elements as intellectual property, geographical indications, and government procurement. In addition, the UK government has consulted on future negotiations to revise the replacement agreements with Canada and Mexico, and has indicated that the agreements with South Korea, Switzerland, and Turkey are likely to be reviewed and revised in the coming years. The UK has reached an agreement with Australia in principle for a new comprehensive free trade agreement. This is the first agreed free trade agreement post-Brexit that has not been negotiated as a replacement of an existing EU free trade agreement. The agreement in principle indicates that the FTA will provide for the almost total elimination of tariffs on trading goods, as well as commitments on trade in services, movement of people, recognition of qualifications, investment, digital trade, and government procurement. The UK has entered into an interim enhanced trade partnership with India in anticipation of securing a comprehensive free trade agreement between the two nations. The enhanced trade partnership investment package contains around £550 million of new Indian investment funds to be implemented in the UK, as well as British export deals to India worth over £446 million. This partnership exists to enhance Anglo-Indian bilateral trade ahead of a future anticipated free trade agreement. On 1st of February of this year, the UK formally requested to accede to the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, CPTPP. This is a trade agreement between 11 nations: Australia, Brunei, Canada, Chile, Japan, Malaysia, Mexico, New Zealand, Peru, Singapore, and Vietnam. China has submitted a request to accede to the CPTPP, and commentators suggest that the USA may make an application to join the partnership too. The CPTPP has indicated its support for the UK joining this partnership through securing free trade agreements via the CTPP with other CPTPP member states, such as Singapore, Australia, and Vietnam. The UK hopes to highlight the importance of trade relations within this community. The security of these free trade agreements are an important step in the UK's accession to the CPTPP, which is expected to occur either next year or the following year. While the terms of trade between the UK and Singapore are unlikely to change as a result of the UK's accession to the CPTPP, because they're already very liberalised, this accession will increase the UK's engagement with markets in the Asia-Pacific region. The CPTPP reduces trade tariffs for goods, as well as sets out rules in areas such as investment, intellectual property, and digital trade. The ambition of the CPTPP is to increase levels of market liberalisation and protect business interests while reducing government interference. As a stable and commercially attractive jurisdiction within the CPTPP, Singapore will benefit by enhancing its position as a hub for UK businesses looking to operate in the region as British commercial engagement grows. So I'd now like to move on to the commercial impact to date of Brexit. And what we've seen really, it's particularly it's during the course of this year, because up to the beginning of this year, we were still in the Brexit transition period, under which really there was very little change. because the EU treaties continued to apply in the UK, etc. So what we've seen since then is a reduction of EU and UK trade. In other words, trade between the EU and the UK in both directions. And a shortage of employees in key sectors. And that's been particularly apparent with a shortage of truck drivers, partly caused by a lot of East European truck drivers who did live in the UK going back to their home countries as a result of Brexit, but also the pandemic. And that has caused supply chain issues. And of course, supply chain issues are a problem all over the world at the moment. But I think in the UK, Brexit has aggravated that. We have well-publicised issues over Northern Ireland, where the UK government agreed that Northern Ireland would remain in the EU single market for goods following Brexit, and that was to avoid a hard border on the island of Ireland. But of course, it created a border down the Irish Sea, which has proved very difficult, both in practice, in terms of checks on goods travelling from Great Britain to Northern Ireland, but also politically, because the population in Northern Ireland is pretty evenly divided between Unionists and Republicans, Unionists wanting to remain part of the UK, who see a border down the Irish Sea as antithetical to the idea of Northern Ireland remaining in the United Kingdom. So there are ongoing discussions with the EU around this, and I understand that a compromise is being inched towards, and the EU so far has proposed a relaxation of certain tests in order to facilitate trade between Great Britain and Northern Ireland, but the UK is saying that the EU's concessions don't go far enough. And there have also been well-publicised disputes with France, in particular, over fishing rights. This is because, again, politically, in the run-up to the Brexit referendum, the UK government highlighted that Britain would be taking control in, amongst other sectors, fishing, and giving UK fishermen greater access to UK waters to the detriment of EU fishermen. But particularly the French are claiming that their fishermen have not been granted licenses that they should have been. And this covers not just the UK, but the Channel Islands like Guernsey and Jersey. And that is an ongoing dispute. It seems to have quietened down in the last 2 or 3 weeks. But certainly that has been a difficult issue, and is part of a deterioration, one has to say, in the relationships between the UK and the EU, particularly France, but more generally as well. There seems to be an absence of trust, partly because the UK has threatened to resile from the agreement, the Northern Ireland Protocol, which was part of the EU withdrawal agreement, which keeps Northern Ireland in the EU single market for goods. So that needs to be addressed, because it's very important for the UK that we have very good relationships with Europe. On the other hand, the UK has looked to explore opportunities to strike out on its own and use the freedoms that it's won through Brexit. So we are awaiting news of the government's proposals on public procurement, which are intended to simplify the regime, move away from a very complex EU public procurement regime, which we're still operating. And that white paper is expected any day. There's been a consultation on that. Also, there will be a reform of the state aid rules. The EU state aid rules were actually repealed on the 1st of January of this year, and the government has proposed a new national subsidy law, which will be much less onerous than the EU state aid regime. There won't be a need to get prior consent from the UK government authority before the government is able to help give aid to businesses. There are broad principles. There will be broad principles under this new regime. There's a bill before Parliament at the moment, hasn't been enacted yet. But that is one of the benefits of Brexit that the Brexiteers trumpeted before the referendum. And we've already seen in the pandemic that the government has been able to help and subsidise government companies, bail out companies, largely probably following the EU guidelines, it has to be said. But this new bill will give it more flexibility. And we've also seen the benefits of Brexit in the sense of the vaccines procurement in the context of COVID-19, because the UK was able to procure vaccines much more quickly than the European Commission, which conducted a centralised procurement programme on behalf of EU member states. And the UK was well ahead of the EU in securing supplies of the COVID-19 vaccines, because I think it had its own independent procurement programme. So the Brexiteers trumpet that as a major success. Of course, the EU member states have now largely caught up with the UK's vaccination programme, but certainly initially the UK were ahead. I think it's an interesting question to what extent the COVID pandemic has masked some of the difficulties of Brexit. We've had a question on this, and I think that there is some truth in that. Certainly on travel restrictions, it's not so easy now for a UK national to travel to another country to provide certain business services, but that, because people haven't been travelling as a result of the pandemic, that has been masked. And of course, vice versa, the same applies to EU nationals looking to provide services in the UK. My next topic is effects under English law. Well, in order to avoid chaos, under the EU Withdrawal Act of 2018, essentially, as at the end of the Brexit transition, all EU laws were brought into UK law. So there was continuity, subject to a few changes that were made in a whole host of Brexit-related regulations, changing references to EU institutions to UK institutions. And now we're going through the process, or Parliament's going through the process of assessing each of those laws and deciding which ones to keep, which ones to amend, which ones to keep as they are. And that will go on clearly for a long time. Also, that act preserved the supremacy of EU law over UK laws existing as at the date that we left the European Union. So going forward, that doctrine of supremacy no longer applies, but case law of the European courts is still binding on all UK courts up to the Court of Appeal. So only the Court of Appeal and the UK Supreme Court can actually overrule a prior case of the European Court of Justice. On commercial contracts, a question which Nicola is going to cover shortly is choice of law. And I would say that English law remains still a very popular choice of law for commercial contracts due to the reputation of English law and the judges in the English courts, and also the flexibility of the common law and its very long tradition. So Nicola will say more about that shortly. It's still probably appropriate to review commercial contracts that were existing prior to Brexit, because some of the Brexit changes, some of the customs changes, for example, have not yet come into effect. And so it's prudent, if you haven't already amended commercial contracts, to have some sort of Brexit clause in the contract, which allows review of the contract in the light of Brexit-related changes such as additional costs, delays, changes in regulation, and which suggests that the parties should renegotiate, and if they can't successfully renegotiate, then terminate the agreement. So that's definitely something worth bearing in mind in relation to your commercial contracts. And I'll hand over to Nicola to talk about disputes.
Many thanks, Anthony. Hi, everyone. I'm Nicola Gare, an English solicitor and HFW's Global Disputes Knowledge Lawyer, speaking today on the Brexit impact on dispute resolution and what businesses should know about what Brexit means for contractual clauses specifying the law and courts of England and for judgments of the English courts. But before I start, I think it helpful to clarify 4 things from the outset. Firstly, that Brexit only affects UK-EU disputes. For the purpose of this talk, I'm referring only to English EU disputes. As you may know, Scotland and Northern Ireland have their own systems. And secondly, England is a preferred choice of jurisdiction for many litigants. It is well recognised and respected and has a body of precedent, so gives consistency, and Brexit is not expected to change that. Thirdly, that arbitration, including enforcement of arbitral awards, is unaffected by Brexit. As a result, where you include a London arbitration clause in your contract or go on to resolve your disputes through arbitration, Brexit will have no impact at all. Therefore, this talk is concerned with litigation rather than arbitration. Finally, the scale of the issue should not be overstated. They will not arise in every case, and there are strategies for tackling them, as we're going to hear. So, what are the points to consider with any law and jurisdiction clause, but for the purpose of this presentation, particularly on contracts between a UK party and an EU-based counterparty? Well, you need to consider 1, governing law, also known as applicable law of the contract. 2, jurisdiction, that is the country whose court will determine the dispute. And thirdly, importantly, enforcement. Before we look at the position for English litigation and claims issued post 31st December 2020, Brexit, what about the claims already issued against EU defendants? The answer here is very clear. The position remains as it was under the transition period. Therefore, for jurisdiction, including service and enforcement, the Brussels I, also known as recast Brussels regulation, will apply, under which service will be fast-tracked under the EU service regulations, and the EU courts will recognise and enforce an English court judgment. Looking at the 3 considerations in turn, governing or applicable law of the contract. Firstly, this is perhaps the most straightforward of the 3 considerations. Essentially, the position remains as it was when the UK was a member of the EU. The 2 relevant regulations, Rome I, concerned with contractual obligations, and Rome II, non-contractual obligations, for example, negligence claims, continue to remain in force. Therefore, EU member states will respect such clauses regardless of whether the law chosen is that of an EU member state or of a third country, for example, England, Singapore, or the US. And similarly, Rome I and Rome II have been incorporated into UK national law, and so English courts will recognise EU governing law clauses where agreed by the parties. So my conclusion: businesses should not be concerned about including an English law clause in their contracts. Turning next to jurisdiction and service. Firstly, what is jurisdiction and why have a jurisdiction clause? A jurisdiction clause should be included where the parties want all disputes arising under their agreement to be determined by a particular national court. A party expressly submitting to the courts of a particular jurisdiction will find it difficult to argue that those courts are not the appropriate place for the determination of the dispute. If there is no effective jurisdiction clause, the correct place for the determination of a dispute will be decided by reference to the rules of private international law. This can cause uncertainty and inconvenience and can lead to additional costs and delay in progressing any proceedings. As we'll hear, there are certain advantages to agreeing an exclusive jurisdiction clause. That is, that only the named country's court will hear the dispute. Prior to Brexit and the end of the transition period, jurisdiction and service of proceedings were determined by reference to recast Brussels between the UK and the EU, and the Lugano Convention 2007 as between the EU and EFTA countries, namely Norway, Iceland, and Switzerland. However, as these operate on the basis of mutual reciprocity between states and without agreement otherwise, they don't survive Brexit. As it stands, the UK is now not a party to recast Brussels or the Lugano Convention. The UK government is keen to join the Lugano Convention in its own right, and Norway, Iceland, and Switzerland have agreed, but it needs the agreement of all EU states, and this is still awaited. So where does that leave us now? What are the options? Well, as from the 1st of January 2021, the UK is a member of the 2005 Hague Choice of Courts Convention in its own right, alongside the EU, Singapore, Mexico, and Montenegro. This can therefore be relied upon for England-EU disputes where, 1, there's an exclusive jurisdiction clause. It's noteworthy that the 2005 Convention expressly excludes asymmetric or hybrid clauses, and 2, where the exemptions do not apply. For example, contracts for the carriage of goods are excluded. The 2005 Hague Convention provides that that only the nominated court will be able to hear the action, and all courts where any parallel proceedings are issued will have to pause them until that action is determined. This is actually a positive change, as under the pre-Brexit system, the English courts were prevented by EU law from granting anti-suit injunctions, that is, to stop a party from breaching an English jurisdiction agreement by bringing proceedings in another member state court. This is a tactical disputes process, which I'm pleased to say, has changed as a result of Brexit. There is, however, an important point to note about the date from when the 2005 Hague Convention applies. There is a difference on this between the EU and the UK. The UK says it will apply to contracts concluded from the date when the UK joined as part of its EU membership. That is the 1st of October 2015. But the EU says no, the date should be from when the UK joined in its own right, which is the 1st of January 2021. Until there's a case on this, the position will not be clear. I thought it might be helpful to set out some practical tips on jurisdiction, so here are 4. Where you have an existing exclusive jurisdiction clause on which you'd like to continue to rely, consider re-agreeing it by way of a supplemental agreement. Many EU member states, including France, Spain, and Germany, and also England, have national laws which respect parties' freedom to choose which courts will hear their disputes. Dispute resolution clauses should not be treated as boilerplate. Local law advice will probably be needed on how easy it would be to enforce an English judgment in a particular country. It may in some cases be appropriate to make jurisdiction clauses exclusive so as to come within the Hague Convention. Turning now to service of proceedings. Pre-Brexit and via the recast Brussels and Lugano regimes, parties were not required to seek permission of the English court to serve defendants in the EU. Now, however, the position has changed for claims not issued before 31st December 2020. So therefore, where the 2005 Hague Convention does apply, leave for service out is not required. Where the 2000 Hague Convention does not apply, but where there is an exclusive English court jurisdiction clause, there is no requirement to see leave for service out. But what if neither option applies? Well, in this case, the English courts can order leave for service out of the jurisdiction on parties in the EU under common law rules, as is currently the case for service on many non-EU jurisdictions, for example, the US. Parties would need to show a good arguable case that the claim falls within one of the common law gateways for service out, that there is a serious issue to be tried on the merits, that England is clearly or distinctly the appropriate place for the trial of the action. A couple of tips on service where possible, include an agent for service of process clause in your agreement. That is, nominate someone in the agreed jurisdiction to receive the claim form, thereby avoiding the time and expense of obtaining permission to serve out of the jurisdiction. In conclusion on jurisdiction and service, businesses should not be concerned about including an English jurisdiction clause in their contracts. The 2005 Hague Convention may apply, and if it doesn't, the common law system has proved successful for many years with, for example, parties in the US. Lastly, let's look at enforcement. So you've issued proceedings and you've won the claim, but does Brexit cause an issue on enforcing the judgment in the EU? As with jurisdiction, the key regimes in this area were the Brussels I recast regulation and the Lugano Convention, plus the European Enforcement Order, or EEO, recognition of enforcement of uncontested money judgments across the EU. These rules continue to apply in respect of claims issued or an EEO order made on or before the 31st December 2020. The good news is that the 2005 Hague Convention generally requires any judgment granted by the court specified in an exclusive jurisdiction clause to be recognised and enforced in other contracting states. So, for example, an English judgment would be enforceable in the EU, Singapore, Mexico, and Montenegro. However, there are a number of limitations regarding the protection offered by the Hague Convention. In addition to those already discussed, for example, the exclusion of carriage of goods contracts, it should be noted that the Convention does not provide for interim injunctions or freezing orders. You cannot therefore obtain an injunction if you fear the defendant will dissipate its assets. So what if the 2005 Hague Convention does not apply? Well, in this case, parties may be able to rely on multilateral treaties with specific EU member states and Lugano contracting states. For example, the UK recently concluded a bilateral treaty on enforcement of judgments with Norway. If not, enforcement of an English judgment will be determined by the local law of the relevant EU member state, and many member states enforce foreign judgments under their national laws, regardless of international arrangements, as does England, where it has long been possible to enforce foreign judgments under the common law where there is no reciprocal enforcement agreement in place, as is the case for judgments from the US, for example. The process involves the judgment creditor, that's the successful party, commencing a fresh cause of action against the judgment debtor, the paying party, in the English courts, with the foreign judgment being the cause of action. Some practical tips on enforcement. 1, look at the jurisdiction in which you are most likely to enforce, i.e., where are the assets? 2, which jurisdiction will give you the best options for injunctions? Note the English courts will order worldwide freezing injunctions, not all jurisdictions will. And thirdly, take local law advice on how the judgment will be enforced. So my conclusion in terms of enforcement of English court judgments is that businesses should not be concerned about enforcing these. The Hague Convention may apply, and where it does not, again, the common law system has been very successful for many years in enforcing English judgments in, for example, the US. So in summary, for disputes and English litigation, particularly with EU member state parties, whilst the process around litigating with EU parties has changed, the system remains intact, and businesses shouldn't be concerned about continuing to use English law and jurisdiction clauses. As we've seen, the system works well with non-EU parties and will do so with EU parties going forward. Thank you for listening. I hope that's helpful and look forward to your questions at the end of the presentation. Now over to you, Anthony, for details of how data protection has been affected by Brexit.
Many thanks, Nicola. And just a reminder, please do send through your questions in the Q&A, because we will leave time at the end to go through those. So on data protection, the UK has agreed a reciprocal adequacy arrangement with the EU. So in terms of transfers of personal data between the UK and the EU, those continue as previously. The UK has also announced that it intends to enter into global data adequacy partnerships. So, high-profile exchange of data arrangements with Singapore, the US, Australia, and the Dubai International Financial Centre, along with Colombia and South Korea. So it very much sees these jurisdictions as very important to the UK in terms of business and being able to exchange personal data. And it also has negotiations for such partnerships in line with India, Brazil, Kenya, and Indonesia. On competition policy, I've already mentioned that the UK has repealed the EU state aid rules to give it more flexibility, and there is a national subsidy bill before Parliament at the moment, which will be much more relaxed and not require prior clearance before the government can provide subsidies to businesses. We await news of the public procurement reforms. Other than that, UK competition policy is still in line with EU competition policy in terms of the structure of the law on anti-competitive agreements and abuse of dominance. That hasn't changed at all, nor I think is there any immediate prospect of it changing. On customs, we've seen some changes, but others have been deferred in order to effectively extend the transition period agreed with the EU, and also to allow customs procedures to be updated and relevant infrastructure to be installed. From the 1st of January 2022, so just 3 weeks away, there will be some increase to the procedures. So goods entering into the UK from the EU will require import declarations, and border controls will be enforced. And there will need to be certificates of rules of origin for both imports into the UK from the EU and exports from the UK to the EU. The postponed VAT accounting on import will continue, which has been a big help to businesses. And commodity codes are also being revised for the UK from the 1st of January. And then from the 1st of July next year, there'll be a requirement for full safety and security declarations for all imports into the UK, and new requirements for export health certificates, and requirements for phytosanitary certificates for imports of plant origin, and physical checks on sanitary, that's human and animal health, and phytosanitary goods at border control posts. So essentially the progress of the UK towards being an independent customs country that is moving forward, and we'll see further changes in the next 6 months or so. On sanctions, the UK, of course, still has to honour the security resolutions of the UN Security Council, and traditionally the UK has been a driver of EU sanctions policy, for example, against Iran and Russia, and I don't see any change there. But whereas while the UK was part of the EU, essentially UK sanctions mirrored the EU sanctions. There were a few differences in terms of nominated asset freeze targets, but essentially they were very, very similar to the EU sanctions. Now that's not necessarily the case. So at least theoretically, the UK can impose additional sanctions as part of its foreign policy. And so when companies are conducting their sanctions checks on counterparties, etc., they should do a separate check for under UK sanctions, in addition to the checks that they make in relation to the EU, US, and of course other jurisdictions. So just another jurisdiction to add to the compliance check. Okay, so we said we wanted to leave time for questions, which we have. So I'll turn to the Q&A, and we'll see what we've been asked. we've been asked a question: to what extent has the UK taken back sovereignty and control following Brexit? Which is, of course, a very interesting question, because the Brexiteers really trumpeted the idea of taking back control and sovereignty during the campaign. And for many people, this was the key issue alongside immigration. But I think in many ways, it's a serious issue, because the UK, as a member of various international organizations like the United Nations, has already, in a sense, given up some sovereignty. As I just mentioned in relation to sanctions, the UK has to implement resolutions of the UN National Security Council. So I think in today's world, it's no country can sensibly operate with full sovereignty. And of course, when we enter into trade agreements with other countries, and it's the government's ambition to enter into free trade agreements with many countries, and extending the agreements that the EU had with countries, that again, of course, is to some extent pooling sovereignty, because you're then contractually restricting your freedom. And similarly with control, it's I think it's an ambition to think of that a country should have full control, but in today's interconnected world, that's difficult when there are so many other pressures. And in terms of parliamentary sovereignty, in fact, a lot of the post-Brexit legislation is being made by effectively civil servants. So legislation might nominally be presented to Parliament for rubber stamping, but there's not actually much scrutiny going on because of the sheer volume of it. Of course, the major legislation will require acts of Parliament and full parliamentary sovereignty. Scrutiny, but the vast amount of regulations that have been required post Brexit just don't allow time for Parliament to intervene. And in relation to the free trade agreements that the UK is negotiating, again, Parliament really has very little say in those. Those are negotiated by civil servants. And so I think in many ways there is maybe theoretical taking back of sovereignty and control, but in practice, I don't think really there is a significant amount of taking back sovereignty and control. And certainly, I don't think parliamentary sovereignty has particularly increased. I think that probably the jury is still out on that, but I don't think the Brexiteers can legitimately claim that they've fully taken back sovereignty and control. Let's look at the next question. So, a question for Nicola, really. Are you seeing parties moving away from choosing English law and jurisdiction?
Thanks, Anthony. You won't be surprised to hear me say that no, we're not. I don't know whether my colleagues on the continent, the EU continent, would have a different view to this, but certainly looking at the recent stats that are coming out of the English Commercial Court, which is the court in which you'd expect most disputes to be channeled, of the nature that businesses would become involved in. The data shows that there's still a consistent level of disputes remaining. And of course, the commercial court is mainly an international court. That is, that the parties using the commercial court are mainly from outside of the UK. So many of you on this call may in fact have cases going through the English Commercial Court as we speak. But no, the data suggests that Brexit has not had a negative impact on the English choice of law or jurisdiction. Whether that changes in the coming few years will yet to be seen. But I think for the reasons that I've already discussed in the presentation, English law remains a valid choice of law for many, many parties for the reasons discussed: consistency, precedent, ease of use, and jurisdiction as well. Our courts are efficient courts, and our judges are high quality judges. So I wouldn't anticipate a change in that. A good question.
Thank you very much. Thank you very much, Nicola. Okay, we've received a question around challenges around re-exporting, and have difficulties been experienced around importing parts and then re-exporting a product to an EU country? I think the answer to that is yes, there have been challenges around re-exporting. This is partly to do with supply chain difficulties, which, as I've said, have really occurred throughout the world during this year, partly because of the COVID pandemic. But I also mentioned there's been a particular shortage of truck drivers in the UK, but it's also in Europe as well, and that is partly also because of the post-Brexit regime, whereby essentially drivers are licensed to drive in the UK, and they need a separate license now to drive in the EU. And there has been some flexibility on that, so the limited number of international licenses can be given, but also the attractiveness of the job of a truck driver has come under a lot of scrutiny. You know, the poor facilities, very long hours, onerous testing requirements, etc., etc. So I think there have been challenges, and also just putting in place the different customs procedures. I mean, I think it's taken many months for hauliers to get used to the increased documentation and customs declarations, etc., that have to be made. And those, as I've just said, will be increased from the 1st of January next year as well. So, yes, there have been issues. It's difficult. I think they are gradually being resolved. And you know, the shortage of lorry drivers has reduced in recent weeks. The UK granted a visa to tens of thousands of additional EU truck drivers, for example. And the reason it reduced the number of truck drivers was to try to increase the wages of UK-based truck drivers. But unfortunately, there aren't enough UK nationals who want to do that job to fit the gap. So yes, there have been issues. I think they are slowly being addressed to facilitate cross-border trade. But I think the reality is that whereas under the EU there was no friction, there was frictionless trade, and the ambition of the UK government was that that would remain. Inevitably, with Brexit, there are more frictions than there would have been. And I think over time, businesses will get used to them. But there are instances of UK businesses no longer exporting to Europe and vice versa, just because the additional paperwork and sometimes additional costs just don't make it economic. So that's the price that is being paid for Brexit, some interruption in trade flows. And certainly the evidence is, and whether it may be partly to do with the pandemic, but the evidence is that there have been a reduction in imports and exports between the UK and EU. And that's it's just a fact, and we'll need to see how long that remains. Another question, one for you, Nicola. I think you've discussed the considerations involved in choosing English law and jurisdiction for future contracts. Would you recommend any action is taken for contracts already agreed?
Thanks, Anthony. Again, another good question. Thank you very much. I would actually. and as the questioner quite rightly says, we were discussing and focusing on contracts going forward. But what about those contracts that we signed, last month, a year, 2 years ago, 3 years ago, whatever it may be? I would suggest that these are reviewed. And the reason I suggest this is because of the debate about the date in which the 2005 Hague Convention on Choice of Courts applies. That said, only really relevant to, for that context, review if there's an exclusive jurisdiction clause. So yes, I would review those contracts. And then if it's found that there is an exclusive jurisdiction clause in those contracts, in order to come within the 2005 Hague Convention on Choice of Courts, assuming the EU is correct in its analysis and that convention will only apply and the benefits under it will therefore only apply when it came into force on their analysis, which was the 1st of January this year, then I would put a supplementary agreement in, just confirming that the intention of the parties is for that to be included. And to have an addendum to those agreements. I'm conscious of time, so my answer is quite brief. I think we have another question that we'd like to fit in, but yeah, I would definitely do a contractual review, and we're here to help. And Anthony has already been undertaking many of these, so absolutely, that's something that should be done. Thanks, Anthony.
Thank you, Nicola. And we've just had a final question, which is the UK government has reportedly demanded that the supremacy of the ECJ should be removed in any renegotiated NI Northern Ireland protocol. What would be the implications if the EU were to agree to that? And I think that's a very good question. And this is a very hot topic. I think it's very difficult for the EU to agree to that because under the NI protocol, the UK agreed that Northern Ireland would remain in the EU single market for goods. And I think that is fundamental to the EU in order to avoid the hard border on the island of Ireland. And if EU law is going to apply to Northern Ireland, in relation to goods at least, then it's hard to see how the EU could agree that its own court should not have jurisdiction over that. So, and of course, if it did, then that could create inconsistencies with the single market. Because if you had another court which was not bound by EU court precedent, which could apply its own law, you could then have parallel jurisdictions of a new Northern Ireland court or whatever, which was independent of the European court, developing its own law, and then that's contrary to the idea of a single market. So I think that's very difficult for the EU to agree, and I think it would be a threat to the integrity of the EU legal system and the EU single market if it were to agree that. So I think got through the questions. Thank you very much to everyone for attending, and do get in touch with Nicola or me if you have any further questions. And thank you very much to the British Chamber of Commerce in Singapore for organising the webinar so efficiently. Have a good day or evening, depending on your time zone. Thank you very much.
We've just held a really fantastic session, and I was delighted to be joined by Anthony Woolich, partner at HFW, and Nicola Gare, a global disputes professional support lawyer from HFW as well. It has been 5 years since the UK voted to leave the European Union, and today's session we talked through a number of elements of Brexit and where we are today around the UK's trading relationship, around commercial impact, effects under English law, disputes, data protection, competition policy, customs and sanctions. Anthony, really keen to hear how you felt the session went and if there are any sort of key takeaways you can share.
Well, thank you very much, David. Yes, I think it was a very interesting session. For example, we looked at the commercial impact of Brexit to date. We discussed the reduction of trade between the UK and the EU, partly due to the shortage of truck drivers and businesses getting used to the new customs procedures. We talked about the difficulties over Northern Ireland and fishing rights, and the deterioration in political relationships between the UK and EU member states, including France. But on the other hand, we talked about how the UK is introducing a new national subsidy law, which will be more liberal than the EU state aid law. It'll also be introducing public procurement reforms, and the UK could claim that a benefit of Brexit has been its success with its vaccines procurement, where it procured vaccines ahead of the EU. So I think the jury is out, but I think for the Brexiteers to claim that they've taken back sovereignty and control is a moot point, because I think in many ways that sovereignty and control is blurred.
Oh, fabulous! And Nicola, how about yourself? What did you feel sort of the key highlights and takeaways were from today's session?
Well, thanks very much, David. I agree with Anthony. I thought it was a hugely positive session. I thought audience engagement was very high. So far as disputes are concerned, as you know, we covered, why businesses for this audience in Singapore should remain confident about using English law and jurisdiction in their contracts. And Brexit hasn't affected that. We have many systems in place which change but don't take away from the benefit of using English law and jurisdiction. It was the case before we joined the EU, and it's the case after now we've left the EU. I thought one of the questions was actually quite insightful, and that was how to approach contracts that have already been signed. And as discussed in the session, I provided what I hope is a helpful solution to that, which does involve reviewing these contracts and perhaps putting an addendum in place in order that they can then come within the 2005 Hague Choice of Courts Convention. But again, watch the recording, and all the answers are within the hour of the recording. But thanks very much, David.
I can't quite believe it, but this was the Chamber's final webinar of the year, and wow, it feels like it's been a long 2021. But we're all full steam ahead with the planning for next year. And I'd just like to highlight a couple of fantastic webinars that are coming up that you can see on your screen now, particularly the planning for sustainable growth and future of tourism in Singapore. So two things around tourism and travel and what's happening around the pandemic, but also a post COP26 piece as well. So some really, really good things that are coming up at the beginning of the year. You will receive a feedback form, so please do fill that in. It really helps me and the Chamber team to understand what you'd like to hear more of and how you felt today's session went. We always look forward to receiving feedback to help shape great content for you in the future. So that leaves me to say a final thank you to our brilliant speakers. Thank you so much, Anthony. Thank you so much, Nicola, and to HFW, and to all of you who have joined us today. The Chamber team and I look forward to welcoming you at another event soon. Hopefully in the not too distant future. But in the meantime, have a wonderful festive break. And if you are traveling, stay safe and have a great rest of your day. Take care.